topics and opinions expressed in the following show are solely those of the host and their guests and not those of W4CY Radio, its employees, or affiliates. We make no recommendations or endorsements for radio show programs, services, or products mentioned on air or on our web. No liability, explicit or implied, shall be extended to W4CY Radio or its employees or affiliates. Any questions or comments should be directed to those show hosts. Thank you for choosing W4CY Radio.
Welcome to the Ask the Expert Show on W4CY Radio and Talk4 TV, where we bring you educational information from experts on such topics as legal, health, financial, and home improvement. Now sit back and listen to our experts in community association law, estate planning law, tax relief, Medicare, public insurance adjusters, neuropathy treatment, business brokers, and personal injury law, along with many other topics. Now here's your host for the last 17 years, Steve O.
South Florida, welcome to another Ask the Expert show. You know, this is the problem you have when you do a live show. Sometimes things go crazy, like they have with us today. But we have got a great show for you today. This is our first Thursday of the month. That means K. Bender Rimbaum, Community Association Law. And we're going to be talking to this is our longest running expert. We've been doing this for 14 years, attorney Robert K. We got on, attorney.
Mm-hmm. Hello, everybody.
I got to tell you, you know, I've shared this with you several times before, but now that we're on TikTok, we want to welcome all of our TikTok viewers and listeners. If you live in an HOA or a condo, you're in an association, you're going to love this show. He's not going to like me saying this. This is the top community association law firm in the state of Florida. Robert, we've got all these new viewers and listeners. Can you tell us about K. Bender Rimbaum?
Sure. K. Bender Rimbaum is a law firm that specializes in the area of community association representation. We provide the day-to-day legal advice and guidance and assistance on all aspects of whatever a community association may need. And we do so out of our 4 offices located in Pompano Beach is our main office. We have an office in Palm Beach Gardens. We have an office in Orlando and one in Tampa. We're also pretty much covering the whole state through the Zoom mechanization that's come about in recent years. All aspects of community association representation consistently for the past 35 years.
Well, this is such an easy show to do. The reason why is because of you, our listeners and viewers. You write in so many questions. Sometimes we've got 60 or 70 questions, which we have to go through because the show's only 50 minutes long. Today's a little bit shorter with all the problems we've had. We're also going to be talking about, Robert, the firm does so much free education. So we're going to be talking about all the classes you've got coming up this month.
Got a good month.
Yeah, busy month. So we're going to just get to the questions. We've got questions from all over South Florida. Let's just get started with Vern in Aventura. He said, I really enjoy your show. I keep telling my board they should interview your firm. I'm thinking of running for my board. What qualifies for a good board member?
Well, there is no one set of circumstances that creates a good board member. But what it takes to work best within the community is dedication of time, dedication of energy, dedication of understanding as best you can, and keeping an open mind on the issues that come before the board from time to time. You have to be able to work with others. It's important that you're able to attend meetings and be available as needed, and that you have enough time to give to whatever's required within your association. Every community has unique needs, so depending on where you live, what's going on there will typically determine, what makes a better board member than somebody else. Having some knowledge in the area is helpful. It's not mandatory, but be prepared to listen to the experts that the association hires in management and accounting and engineering and the legal, and make your decisions based upon that. And also important that you're able to make decisions, because board members have to do that.
I think we've been doing the show for so long. So many people think you've got to have a resume that.
Well, in some communities, they like to see that within the membership.
Oh, really?
But it's not a legal requirement.
Okay. So I think that explains it. Ben and Davey, this is about your firm. Does KBR advice extend to guiding associations proper, not-for-profit corp regulations and procedures?
Well, certainly all community associations are generally run by corporations, and the vast majority are under Chapter 617 of Florida statute, which is the Not-for-Profit Corporation Statute Act. And that particular statute lays out all of the procedural requirements for how a corporation of that nature operates. In fact, it was significantly amended this year. So that's not effective until next month. But I don't think it'll substantially change the way community associations will operate. But yes, we absolutely provide guidance and assistance on corporate functions.
Kathy in Boynton, she is a condo. And please, when you write your questions in, let us know if you're a condo or an HOA. It does make a difference. Kathy is a condo. She wants to know, is a fictitious name procedure required for associations to protect the name?
Well, no, a fictitious name is when you're going to use a name other than your corporate name or the name of your community. We've had clients through the years that, for whatever reason, decided to change the face by changing their name. And to do that, there's statutory procedures in place with publication requirements to allow for, it's basically a doing business as in a fictitious name. Community associations, generally being incorporated with the state, their names are protected because the state doesn't allow multiple corporations of the same name. So once you're incorporated with the state of Florida, you don't have to worry about somebody else using your name.
We have carry laws here in Florida, and I'm noticing, Robert, we're starting to get a lot of questions about carrying. Here's Randy in Delray Beach who wants to know, how do you respond to the Florida State Attorney's chastisement of the tradition HOA's attempted ban of weapons from all common areas? I know every time I've asked for opinions on the legality, I get nothing.
Well, that is a difficult area in the law currently, particularly in the state of Florida. The reasoning that the Attorney General used, and there has been recent news on this on a community up in the Palm Beach area, the reasoning that the Attorney General used had to do with employees statutory limitations. And that's not the situation in a community association. A community association is private property. And the law for my whole career has been that private property is not subject to constitutional issues when it comes to things of that nature. Now, housing constitutional protections, of course, are in place, but the Constitution overall doesn't necessarily apply within private communities under private contracts. But the Attorney General has reasoned in this situation that a private community rule of this nature is subject to enforcement by Florida as violation. And I think that there isn't any community association that wants to take on that that fight with the Attorney General at this point.
Okay.
So basically, open carry
This is from
is something that
Go ahead.
should be happening in most community associations.
Beth in Boca Raton. Our HOA management company was bought and old corp was dissolved. We still have old contract with old name of company. Should we be concerned?
Well, certainly there's some concern how the changeover took place. Generally speaking, in contract law, unless the agreement between the association and the management company does not allow for the assignment of the contract by the manager to another management company, which would be what would happen in the sale of the company, then that could happen. And then the contract just shifts to the new management company. What would be a good practice in this situation is to reach out to the new managers, whoever the principals are in that company, and get updated contracts. The old contract should still remain effective with the new owner, but there are some legal issues that you'd want to tie down by getting a new contract in place.
Okay, we're going to go to the chat line. What can a board do to entice those recently elected to be an officer? We've had several elected members who want to be on the board but not on official. This leaves us short of officers. In the future elections, can a requirement be that a candidate must assure, if elected, they will not turn down a nomination and subsequent elections?
Well, there's nothing in the statutes and case law that would allow for such a limitation on an individual running for and being elected to the board. There is no way that you can force any individual who's serving on the board to also take on the position of officer. Now, bear in mind, officers and directors, while they can be the same people, serve different functions for the association, with generally the board making and setting policy for the operations of the association, and the officers being the ones who carry out that policy. For many communities, only the president and possibly vice president are required to be members of the board. But check your bylaws to see if there's a requirement of board service to be an officer. If you're in a situation when your documents don't make such a requirement and you do not get anybody from the board willing to serve in the offices, then you can look outside of the board to other residents in the community to serve that function. They don't have to be board members necessarily unless the documents say so. Typically, the president is required, but you do want to check your documents on that point.
Tracy in Boynton wants to know, what's the liability of the association president of a condo association that gets a key to access everyone's units without anyone knowing?
Well, there shouldn't be keys being obtained without anybody knowing. In fact, in condominium law, the board has a right, an entitlement to have an access key to every unit. And they do have to maintain security of the keys and make sure that they're not available to other people getting them, and that access is undertaken only under identified circumstances that pose a potential threat to the common elements or other units. But there is no actual liability for the president having keys. If they're getting them in secret, that's a very unusual and strange situation. And that's something that should be looked into. There should be open communication, and it's a absolute entitlement under the statute that the association should be able to receive an access key from every unit owner once they've adopted that policy. So that community might want to get with their council to get that straightened out.
Yes. Larry in Delray Beach, he said, we have more people complaining about people smoking pot in their own unit, and it's permeating through to the neighbors' units. Do the neighbors have any recourse?
Well, I'm assuming this is a condominium, it sounds like, but
Yes.
this Chapter 718.303 does allow for unit owners to bring action against neighbors if the neighbor's conduct is somehow interfering with the unit owner's quiet enjoyment and use of their property. Under those circumstances, it is possible to bring an action. Now, whether that action would be successful is another situation, because assuming that the marijuana is being used as medical marijuana, that would place the user under the protections of the Fair Housing Act of having a disability, and it would be necessary, I think, for that owner to have made a request to the board for reasonable accommodation, acknowledging their use of the marijuana within the confines of their unit. In that situation, if an owner were to attack that use through legal means, it's possible that the user could have a discrimination claim against the owners that are complaining or filing legal action against them. So it's a very difficult situation to try and address.
What about, I've actually had letters from people who have said that the next door neighbor smokes cigarettes and they feel like it's going through the vent and they're getting secondhand smoke. Is it the same with cigarettes?
Well, cigarettes is not the same in that there's no medical entitlement to use it. So with cigarettes, typically the association would have to have an amendment to their declaration of condominium that prohibits the use of tobacco throughout the building. Otherwise, if it's by rule, the board can only do so in the common areas, and the owner would be able to smoke within the unit. In that situation, if a neighbor is bothered by the smoking within the unit of cigarettes, then that owner can certainly take action against the neighbor for the nuisance. It's not an easy claim to make, but it is something that might be able to be completed.
We just got a question from TikTok. I just found your show. Thank God there's a show out there like this. Can you tell me, we have limited amount of handicap parking. Can we hire a tow company as long as we put a sign up and have those cars towed away that are parked in, legally parked in the handicap zone?
Well, I guess it depends on what you call legally parked. In community associations, the handicap parking is supposed to be for guests, not for residents, unless a resident has a particular need for one and makes a reasonable accommodation request under the fair housing laws. If somebody is parked with a valid permit in a handicap spot, removing that vehicle involuntarily would subject the association to probably significant financial consequence for doing so. It is not recommended to do that. It is important that communities do have rules in place to identify who's supposed to be using their handicap parking spaces, and it's not just an open free-for-all.
You know, Robert, one of the things I love about your firm is your firm gives so much education out there, free education out there. And every month we go over all the classes that you offer. Can we go over your June classes?
Yes, let's do that. And do mention it is scrolling, I believe, on the screen. But in addition to the classes I'm about to talk about, there's also on our website, kbrlegal.com, under resources, there's a large amount of topical articles on all sorts of issues that are facing community associations. And some are more recent, obviously they're more timely, but even the older ones have continuing use, and that's something that's available to anybody. It's not just for our clients. So the first is on June 10th, a Zoom at noon, HOA record keeping and records access. This will provide a continuing education unit for a HOA board member and one for managers managing HOAs. It's hosted by CAI Gold Coast chapter, and it will be led by Danielle Brennan of our Palm Beach Gardens office. On June 16th at 11 a.m., also on Zoom, funding construction projects, loans, assessments, and reserves. There's a credit for HOA board members on this and one for managers, hosted by ACAM, and will be led by Peter Molengarden, also of our Palm Beach Gardens office. On June the 17th at 2 p.m., also Zoom. In fact, they're all Zoom this month. 2026 legal update, which is changes in the laws from 2025. There is a condo board member credit. They have one that they're required each year. So that would cover them for the year, and two for managers. This will be led by Emily Gannon out of the Pompano office. On June the 24th at 10 a.m., there's a 4-hour condo board member certification course. It's for new board members of Condominium Association, hosted by Empire Management. Although any member can sit through it if they want, it is a requirement for new board members. This is going to be led by Alan Schwartzide out of our Orlando office and Kirsten Hens from Tampa. They'll be tag teaming that since it's 4 hours, and that's a lot of material to go over. On June the 26th at 12 p.m., HOA meetings, notice requirements, member participation, elections, and voting. This has 2 HOA board member credits and 2 for managers. This will be led by Kirsten Hens of our Tampa office. And the last for June, on June the 29th, again, the 2026 legal update with the condo board member CEU and 2 for managers. This will be led by Alan Schwartzide from the Orlando office.
Busy month.
Busy, yes. Getting to be summertime.
No kidding. Let's get back. I'm going to skip through the commercial today.
Might as well.
And I want to let everyone know, include Juan, our great producer, we're going to replay the show again tomorrow at 2:00 Eastern time. We'll be replaying the show. We just had some technical problems. I don't remember last time we had these kind of problems. But let's get back to the questions. Billy and Pompano, is there a limit to the ESA per unit that is allowed?
Well, ESA is something that's recently come into the foreground once again. There has been some recent publication through HUD, the Housing and Urban Development Department, that oversees fair housing issues, that indicated the intent to no longer enforce on ESAs in housing. The only enforcement on animals, based on the memorandum that's been published, is that service animals, such as seeing eye dogs, animals that are specifically trained to provide a specific service to an individual, are those that will fall within the enforcement actions of the fair housing agencies. Now, whether or not the local agencies have that message yet is still an open question. This is pretty recent. It's within the last couple of weeks. If this goes as it seems to be going, the issue of emotional support animals in housing situations will no longer, for the most part, be something that individuals can use to get around no pet rules. But as things have stood, the laws that were enforced did not have a limit on the number of ESAs. That had requirements of providing information from qualified medical professionals as to the specific need of the requesting individual identifying major life functions that were being impaired without the use of the support animal, and that the support animal is specifically in place to assist with those issues. There is no limitation on number. There is no limitation on weight if they qualify under those rules. But as I mentioned, that may no longer be an issue that the federal agencies will be enforcing. There remains the possibility of civil litigation if an individual thinks that they've had their rights violated and they want to file a lawsuit against the association. But under the circumstances and the new interpretation by HUD, that might not be a very strong lawsuit. It's still developing, so maybe in the next coming weeks and months we'll see something more solid on that.
Okay. Let's go to Craig in Aventura. He wants to know, what if the board of directors' terms have all expired? No member quorum achieved. What do we do then?
Well, this would be helpful to know if it's Condo HOA, but typically, assuming the old board is willing, they would roll over to another term if there is no quorum to have a meeting to replace them. In a condominium, that's a little more problematic in that the laws are written differently as far as how the election process works. So it is, if they go forward, it's possible that there'd be no board, and then the only possible remedy, if you couldn't hold another election, would be through a receivership that somebody would have to file for in the circuit court, not the state of Florida, but through the circuit court. But if an association is facing that possibility, it's a strong recommendation they get with their attorneys beforehand so that they can avail themselves of all possible options. One possible option in a condominium, if you know you're not going to have enough and you don't want the current board to expire, would be to cancel the election before that happens and reschedule to a later time, and starting the process over again with a new 60-day notice. But it really will depend on the circumstances in each situation.
Hey, Robert, would it surprise you if I told you we are starting to get a lot of letters from owners about electronic cameras, especially with doorbells?
Yes, that has been a growing issue of recent times. Yeah, because they're so much easier and so available.
Yes, and everybody's getting them now. Here's Phil in Boynton wants to know, does the electronic camera have to have signage that their voice and video are being recorded?
Well, if we're talking about on the common elements that the association has placed, the association has to provide notice. We do not recommend that associations record audio because Florida is a two-party consent state. But Ring cameras don't seem to fall within that category, and for the individual's use at their home, I think it's probably common knowledge that they do have audio recording in them. But I haven't seen anything testing that. So it's an interesting possibility that somebody could make such a claim. I'm not sure how far that would go, though.
Well, I just heard a company yesterday saying they will give you free Ring, the ringer out there, the cameras. They'll set up all the cameras for free. You just got to pay for the service each month. So it is becoming easier to get, and we'll just have to see. Let's go to Barry, another Aventura. I'm in a HOA where the developer is the board. The board put in writing with violations that after the first notice, they will send to an attorney if not corrected. No other notices, no finding committee, just to the lawyer. Is that legal?
Absolutely, yes. There's no requirement that an association implement a fining policy or procedure. That's an alternative method of dispute resolution that is made available by the statute if an association doesn't want to do formal legal action, which can be expensive and for certain violations kind of hardly worth it. But if somebody leaves their garbage cans out for 2 extra days after the pickup, it's unlikely you're going to bring a lawsuit for that, because by the time you do, the problem has been resolved. So fining is probably something more useful for that type of violation. But there is no limitation that says the board has to do anything other than refer it to the attorney if it's a bona fide issue of violation.
I'm going to go over to our chat line. This is Condo Association. If there is no bylaw establishing a timeline when a visitor becomes a resident, triggering on application and approved to live in a condo, what determines a change of status?
Well, that's a difficult problem because there is no guidance that they can use. If the documents are silent on the amount of time that a guest can reside in a unit without having to submit application or be considered a permanent resident, then the presumption is that there is no restriction. So that would limit the ability of the board to adopt a rule that holds to that effect. What would be necessary in that situation is for the community to adopt an amendment to their covenants or declaration of condominium, for whichever it is, that provides for those limitations and specific timeframes. And that would require a vote of the owners based on whatever the documentary requirements are as to the percentages.
I'm going to go to Jen in Palm Beach Gardens. Is it okay for a president to create a code of conduct for the board?
It is not okay for the president to create a code of conduct because that does not fall within the purview of what a president does. It is possible for the board to adopt a code of conduct, which would be advisory at most. There is nothing in the law that compels a board member to follow a code of conduct that is adopted, but it's a political issue if they do not. But the president does not have the authority to create such a document or a policy unless the governing documents expressly provide that power.
You know, we also get so many questions on Zoom meetings. Here's Barb in Boca Raton. I love your show. What are the rules if you decide to have a Zoom meeting?
Well, generally speaking, there's different types. There's board meetings and there's member meetings. And in both sets of circumstances, it's now a requirement that in addition to the Zoom availability electronically, there has to be a physical location for people to go that don't want to use the Zoom option where they can view it and hear it and participate from that location. That's the main consideration. It has to be available for everybody to participate with. So that's the main criteria.
Here's Kenny and Delray. Our board never misses your show. Thank you so much for educating us. What percentage of disputes are settled instead of going to litigation?
Well, I don't have an exact number on the percentages, but I would say it's probably close to 90, if not higher. The vast majority of disputes do not reach, well, they may reach litigation, but they don't reach trial. Trial is very rare. It's a much lower number that percentage-wise that do reach litigation. But I don't know that anyone's tracked such a percentage. It really depends on the parties more so than the statistics.
Kenny in Sunny Isle. I don't believe we've ever had a letter from Sunny Isle, but for an HOA, the board passed a special assessment for major clubhouse repairs. An owner believes that the governing documents require an owner vote. The board disagrees. What are the owner's options?
Well, it really is going to depend on the specific language within the documents and the repairs or whatever work that is being done. Generally speaking, if the work is necessary repairs that falls under the obligation of the association under the governing documents, the board has the absolute responsibility to undertake those repairs and assess for their costs, regardless of what provision the documents say for an owner vote. This is based on case law from the early 1980s and has been followed pretty much routinely for the past 45 years or so. However, if the change is a capital improvement, putting something in that wasn't there before, putting in a tennis court where you had grass, or creating a whole nother level within your clubhouse. Those most likely are the capital improvement types that would require a vote of the owners if the documents so provide. So it really depends on the documents and the specific nature of the work that's being done.
You know, Robert, our show still reminds me of the couple of times we went to listen to you, you and Michael both. You had a question. I think it was going to last for about an hour and a half. We went there. It ended up going over 2 hours.
It was our old road show.
Yes. The guy sitting next to me said, I got one question. I'm out of here. This guy ended up asking at least 8 to 10 questions, and he stayed for the whole thing. So
there's always something.
It's amazing, and you always do. When do those start back up again?
Well, I don't know that that's in the cards. Every once in a while we do something local, but as far as the traveling road show, COVID kind of put the kibosh on that, and Zoom created the opportunity for a lot more people to participate. So we found that we've gone the Zoom route more. I kind of like the old road shows where we'd go to various places around the cities, and whoever came out, whatever questions they asked, we would address them. It's possible it'll happen again.
So you've got this great website I want you to share with everybody, especially those who cannot view the show. And how can people reach your office?
Well, the website is at kbrlegal.com, KBR like K. Bender Rembam, legal.com. You can reach us at 800-974-0680, or on the website, there's a contact box on the first page, or send an email to info@kbrlegal.com.
You're with us the first Thursday of the month at 5 o'clock Eastern. And again, Juan, we're going to replay this show tomorrow at 2 o'clock Eastern time. So
I'll be there.
Yeah, you'll be there. So we'll see you again next month. Hey, stay healthy, please.
I'm doing my best. Thank you.
We need you. Okay. That's Attorney Robert K. Bender Rembam. That's going to do it for us today. We'll be back again with our Thursday show next Thursday. Stay tuned. And again, we'll be back with you tomorrow at 2 o'clock Eastern time. See you then.
Thanks for tuning in today to the Ask the Expert show on W4CY Radio and Talk4 TV. Tune in next week and every week to hear more from our experts on personal injury, insurance, air condition repairs, estate planning, Medicare, and many other topics in the areas of legal, health, financial, and home improvement. See you next week.